Hello and welcome. My name's Alan Fowler. I'm with Garris Horn, and I'm introducing our latest installment in our HIT webinar series. In this case, HIT stands for High Impact Industry Training. These sessions are designed to deliver focused, actionable insights on critical issues in mortgage compliance, legal risk, and operations, all in a format that you can actually fit into your day. Today's installment is Beyond Firewalls, Preparing for Cyber and Privacy Exams in the Age of AI, and is presented by our senior partner, John Levonick. John's a nationally recognized authority in regulatory compliance and data privacy and financial technology. So, let's get started.
Well, here we are at the top of the hour. I want to thank everybody for joining us. My name is John Levonick, and very excited today to talk about the adoption of AI and the mortgage lending industry's concerns and risks as it relates to the adoption of AI. AI is a prevailing force within our industry. Every day we hear of a new opportunity, new product, new service that's AI enabled or AI driven. And the mortgage lending industry is ripe for disruption due to the use of AI. So many mortgage lenders are rushing to experiment, to work with various AI tools to ensure that they are not left behind and actually working on the bleeding edge of technology. So my job here today is to tell you as a financial institution, tell you as a vendor what you need to know in not only the adoption of AI, but effectively the providing of AI-enabled services to the financial services industry so that everyone is on the same page for when the regulatory authorities come in and question and sniff around that the financial institution, supported by their vendor, have the right artifacts, the right knowledge, comprehensive understanding of what's being done, how it's being done, to satiate the regulator's concern and to make examinations as efficient as possible. No need to introduce myself, John Levonick. A 20-year regulatory compliance attorney working with emerging tech. Find myself now supporting financial institutions and mortgage lenders and AI technology service providers with regulatory compliance understanding, governance, and best practices as it relates to the adoption of this technology. Because today is a high-intensity interval training webinar, we have 30 minutes. 30 minutes to get through what I think is 15 plus slides. The goal today is to make these slides available to you. I'll be working with our team, Editors in particular, to disseminate this deck to all the participants. So we look forward to not only talking you through it, but having you give this, provide this deck to you as a takeaway, which provides some pretty comprehensive understanding. So without further ado, let's get into it. First and foremost, we're going to talk about use cases of mortgage lending. We are then going to jump into where the risk lies and whether or not that risk is hidden. We're going to talk about core AI and model governance, what that means when LLMs are being used directly by the lender or indirectly through a service provider, what's necessary to quantify, qualify the risk, and bring forward an AI level of knowledge to your governance, risk, and compliance program. We're going to talk about governance gaps, where the risk lies in today's GRC programs, third-party risk and licensing implications. Yes, we hear about the use of AI in conjunction with CRMs, with conjunction with LO support. Where does the AI automation and activity potentially cross over into what may otherwise be a licensable activity if it was a natural person providing that service? We're going to do a high-level overview of generative and agentic AI risk as they are different, and a brief explanation on the difference between the two. And then finally in this deck, what most presentations don't provide you that I'm happy to provide you is you are going to walk away with an actionable compliance framework, an understanding of what needs to go into your compliance framework to adopt or deploy AI. So first and foremost, the use cases. We are seeing a lot of use cases in the support of LOS and point of sale solutions. I should have included CRMs as well. The use of AI in conjunction with CRMs to assist loan officers in reaching out to prospective borrowers, reaching out to borrowers that have inquired into a product, and the use of AI and the ancillary services as relates to the point of sale and then the loan origination. The AI-driven, we are seeing AI in credit decisioning, income assessment, and to what extent can the adoption of AI work when supplementing a credit determination or supplementing an underwriting decision? LLMs that are used to summarize or classify documents as part of loan origination or QC, that is everywhere. Probably the most predominant use of AI we see in our space right now is docs to data, and the various uses of docs to data with some cursory level data validations. And then finally, what we're seeing is valuation tools that are incorporating computer vision or predictive pricing, effectively meaning that to supplement the use of an appraiser and supplement the assessment of the underlying or intrinsic value of the collateral, the use of AI tools in conjunction with the traditional appraisal. The regulatory hotspot, managing hidden risk. Obviously, the embedded intelligence may not be obvious to a user. If you have licensed or you're using a loan origination technology as a SaaS, you need to know whether or not that technology is utilizing directly AI-enabled functions or features, or bringing to the table third and fourth generation technologies that are part and parcel to the underwriting process that do use AI. Just because your LOS may not directly use AI doesn't mean that they're not facilitating the use of AI-enabled services. Once again, we talked about the value use and valuation. We talked about the use of it in conjunction with CRMs and point of sale. At the end of the day, as a regulated institution, the financial institution, you are ultimately responsible for all outcomes. You are responsible for use of technology when models are embedded in vendor tools, whether, again, that's a direct vendor, second generation, third generation, fourth generation technology. You need to understand how, when, and what is being used and ensure that you have the appropriate governance over such requirements. Risks related to bias, explainability, and fairness. Fairness and bias, the fair lending concerns. I refer to that as the overarching fear that this industry has. Obviously, fair lending has always plagued our industry as a very subjective requirement that could potentially expose an institution to a lot of risk. AI is no different. The use of AI in services that are related to outcomes that may be skewed or may be directed or driven based on data that is intrinsically discriminatory. If you rely upon variables that are discriminatory, the outcome very well could be discriminatory. So how do you get your arms around bias through explainability and getting your arms around true fairness? And fairness is not always fair lending. Fairness would be use of AI in pre-qualifications. Also in some cases, pre-approvals. Contractual protections. As a financial institution, you must set your expectations with your vendors and their obligations to manage their sub-vendors through clear and pointed contracts. The underlying risk or the underlying obligations to vendor agreements need to delineate clear understanding of what AI is being used, representations and on model performance, reps and warrants as to model performance and objective metrics to measure that model performance, and obviously compliance. Audit rights and access to model explainability artifacts are huge. Financial institution needs to have the right to ask tough questions. They need to be armed with a list of the right questions to ask. They need to make a determination that their vendors and sub-vendors are following the obligations for which the financial institution is going to be held to by the overarching regulators. And finally, remediation obligations. What happens if something goes wrong? What happens if something goes sideways? What is the vendor going to do? What are the liabilities? What are the limitation of liabilities? What are the potential indemnities? Those elements of a contract that make people's eyes glaze over. These are vital, and not only ensuring that your regulatory obligations are met, but in the event that you are penalized financially via a civil lawsuit or a potential regulatory enforcement action, as a financial institution, do you have financial recourse against the vendor and the vendor's sub-vendors for when things do go wrong? All right, core AI governance deliverables. At the end of the day, a very vital element and requirement is that the technology provider, whether it be directly used by their financial institution in their own sandbox or through a vendor, has a clear registry of all AI, which includes machine learning, generative, and agentic statistical models. Whether they are being actively used, whether or not they've been retired, and or if they're under development and used ancillarily or in an ancillary manner to the current model that's active in the current version of the deployment. Obviously, deployment methodology in the software development lifecycle around AI is very important. Clear identification of models. Every time a model is touched, every time a model is impacted, every time there's potential injection risks from a third-party nefarious actor who may have potentially injected bad data, each model needs a unique identifier. That identifier represents the version, whether or not when the version was deployed, the aging of the version, and also tracking along with what was done to that version, if hot fixes were done in line, if any types of enhancements were provided to a technology that's in current production. Obviously, if something's not in current production and it's in staging and test, obviously a new ID and version ID would be assigned to that. Whom owns the LLM? Who owns the model? Who's responsible for the model? Where the data is derived that is being used in any particular model? How the data is being validated. Data validation is going to be an overarching theme here. An AI-driven model is only as strong as the underlying data for which drives its determinations, its outcomes. So validation of data is enormous, and proof of how data is validated is clearly required. And obviously a risk rating. The user of the AI needs to understand the risk. We're going to talk about gaps here in a minute. Where does the risk lie, and how do you quantify and qualify and protect the consumer from any probable harm that might derive from the use of that particular AI model? Once again, software development lifecycle, the lifecycle documentation needs to be completely clear, definitive, and it needs to be part of a vendor's governance, risk, and compliance program where the financial institution who may be licensing it or using it as a service has access to the most recent and updated collateral as it relates to each and every version, each and every revision, and each and every iteration of that tool. Deployment determinations and implementation logs. Obviously, that's a technical requirement that can be provided by the underlying technology provider. And very importantly, what is being done on an ongoing basis to monitor, to validate, to recalibrate, and then what are the drivers for retirement, whether it's aged out, a new version, a hot fix, defect. What are the drivers to retiring prior versions? Explainability is enormous. You cannot use any tools that are deemed to be in what's called a black box. A black box is a reference to the fact that the outcomes and how outcomes are derived is controlled and maintained in an opaque manner, meaning very often and quite often I deal with technology providers who do not want to provide clear visibility into how their AI-driven software works because of fears of people stealing ideas, stealing and IP protection rights. That is no longer relevant. IP can be preserved, but the explainability needs to be clear and evident to the user. Obviously, adverse action. If you are using AI in relation to any determination of creditworthiness, any action that the AI undertakes, whether it's to, most importantly, to deny if a prospective borrower is denied for whatever reason, there needs to be clear mapping and a relationship to the rational justification for which the determination was made. So that'll address your COA and Reg B requirements. Also, each and all and every element of supporting logic must support the determination that was derived, and that rational nexus needs to be provided to the consumer. The consumer needs to understand if I as a consumer were declined for a potential mortgage, I need to know exactly how or exactly why, and there needs to be a rational basis for why it was done, supported with evidence. And obviously, an organization's internal governance policies for adoption and use of AI and ML, basically what types of hires need to be made, how to enhance your governance and risk team, whether or not, if you're a publicly traded company, a director is appointed with the direct obligation of overseeing and being responsible for any AI and ML use. And obviously, detailing each of the elements that we've basically just addressed. We talked about the importance of opaque outputs. Explainability is vital. There needs to be a policy and procedure in place for the financial institution that delineates how an AI is used and under what circumstances the outcome is made and why it doesn't need a human in the loop. You're going to hear the term human in the loop. When these tools act with a certain level of autonomy and no human is there to reinforce the outcome, to say, yes, it's valid, it makes sense, I've checked its work, there needs to be clear documentation of the autonomous nature of the use of the AI and how the appropriate controls are put into place by the financial institution to ensure the integrity of those outcomes. And obviously, there are many, many different models that could be used to identify potential discriminatory outcomes through the use of AI. So obviously, when you're using it for determination of creditworthiness or in conjunction with the determination of creditworthiness, even collecting documentation to support the underwriter who makes the determination of creditworthiness, there needs to be a fairness assessment conducted on this tool to ensure and preserve the integrity of the outcome of the AI tool. Third-party risk. I'm not going to make a lot of friends here from my vendor friends in the audience. Third-party risk is enormous. If a financial institution does not have control of their own proprietary use of AI and their own proprietary sandbox and their own controlled deployment and use of it, when relying upon a third party, there is immense risk. We talked about contractual obligations, contractual expectations, reps and warrants, what the contracts with the vendors need to entail. But at the end of the day, there needs to be clear documentation from the vendor on each of the aforementioned points, because at the end of the day, the financial institution is the entity that's responsible legally, reputationally, and at the end of the day, potentially at risk of civilly for the outcomes of the AI. So you cannot hide, as a financial institution, you cannot hide behind the vendor. You cannot presume the vendor is doing the right things for you, and you cannot get away with not having a comprehensive understanding of the vendor's controls, and how the vendor is fulfilling your obligations as a financial institution. We talked a little bit about the contractual safeguards. I elaborated a little bit more here. Okay, talking about licensing. When using an AI tool or AI underpinned tool, in the event that any function of that AI tool has or mirrors what would otherwise be a determination or outcome that is associated with a licensable activity, something that an underwriter, if the underwriter is required to be licensed, then those underwriters' requirements, if they are used and adopted by the AI, will trigger licensing obligations. Doesn't mean you cannot use an AI that supports the use or supports the underwriting of the tool. You just need to understand unequivocally what is done, where the tool comes short of the triggering activity that would otherwise require a license, and enhances the underwriter as a human, the human in the loop here, enhances their ability to make the determination through the efficient use of AI. I think at the end of the day, we look at the bottom statement. You always need to have a human in the loop validation if the use of AI is part of processing or underwriting, or even the offering of credit. Any activity that would otherwise trigger a mortgage lender license, a mortgage broker license, contract underwriting license or registration, etc. Generative AI. All right, now we're getting into the buzzwords. Generative AI is everywhere right now. Generative AI brings special risks because of the nature of the technology. Generative AI think of it this way. Generative AI provides summaries, provides outcomes based on prompts. You ask it a question, it shall answer. You provided a calculation, it should calculate. You ask it for a summary, it shall summarize. Generative AI is driven by the prompting, the user asking it to do something. Not activity driven, but outcome driven. One of the many risks associated with Gen AI is the underlying data for which the Gen AI was trained upon. There is a lot of news out there today about copyright law, copyright infringements. I think a famous one is a Gen AI tool was trained on a Harry Potter novel, for example. And whether or not the use of the data is permissible data, and that data doesn't trigger an IP infringement. Does it belong to somebody? And do you not have the absolute authority to utilize that data in perpetuity? Meaning, if a client authorizes you access, if you're a vendor, if a client authorizes you access to data, it doesn't mean you can train your model on that data, because even when the client goes away, the contractual obligations for data purge may exist. You cannot purge an LLM for outcomes that were derived from training obtained by the use of data that should not have been used in the first place, where the intellectual property rights did not exist for the training. Gen AI models, very well, and if anyone uses commercially available ChatGPT, Claude, Gemini, whatever, Llama, whatever it might be, people can understand that if I ask it the same question twice, I might not get the same exact answer. That is important to understand, that outputs may differ based upon ancillary information under which that LLM was trained on, access to information, contextual differences. Remember, AI is the LLM is merely a computer that assesses the command. If the command has a geographic vernacular driven change, the use of y'all versus you, for example, that might be sufficient enough to trigger a different outcome. And you can't rely upon a Gen AI LLM to evidence an outcome that had been provided historically. You cannot use it to reproduce a scenario exactly, because the Gen AI tool may have evolved through learning, through training elsewhere, that could give you a different outcome. So do not rely upon it in the event you need to reproduce an outcome. And obviously, the cybersecurity data privacy concerns is prompt injection and manipulation. Nefarious actors no longer are as concerned with obtaining consumer data, because a lot of it's out there in the interwebs. But at the end of the day, nefarious actor may want to disrupt the particular use of AI by a financial institution by manipulating it, by injecting fraudulent data, incorrect data, to lead to incorrect outcomes. So security is a vital, cybersecurity is a vital element to the use of AI. All right, agentic AI. Agentic AI differs from generative AI in a very high level manner, and my technology friends out there, please excuse the rudimentary explanation, but agentic AI is an event-driven use of AI, where generative, it prompted, it comes to an outcome. Agentic AI is a tool that is trained to act and to then take action upon certain commands, requirements, conditions precedent. Agentic AI learns in real time. It learns from itself. It's self-training in many regards. The risk of a material error or a very bad thing in occurring is significantly higher in agentic AI, because agentic AI might have the rights to go to a certain database. It might have the rights to hit an API to drive an outcome from integrated vendor. It might have the authority to act, but if that action is not done in a concise and clear and expected outcome-driven manner, that the additional layer of liability, it's obvious. And that drives the need for guardrails. Logging every day what was done, what the agentic, we'll call it AI bot. In many circumstances, these are termed bots that have the authority to take and undertake certain activities and actions. Logs are vital. The predefined rails for which a decision is derived must be clear and must be explainable. And obviously, in the event that the bot malfunctions or does not function in an appropriate way, there needs to be an easy cutover back to a manual process. You cannot be a holistic reliance upon the AI bot entirely, because if it goes, off the rails, so to speak, there needs to be a break glass push button scenario where it's overridden, the appropriate parties within your organization are alerted, and you can continue with your business operations while being in a more manual basis, but still continue with business operations. All right, actionable legal and compliance framework. This is probably, this starts a section on the elements for which an organization needs to account when using AI, whether it's machine learning, it's generative AI, or agentic AI. Obviously, vendor management, I'm not going to go through an explanation of each of these because we do have 3 minutes left. Vendor management, the strong third-party controls that's driven by your contracts. The contracts have to be clear. Company infrastructure, we talked again, having the right governance team in place, having the right well-educated executive team in place to make smart determinations with a full understanding of the risk for which the financial institution is undertaking. The alignment with IT frameworks and IT framework guidance. This is the security, privacy, and controls of the model underlying obligations. While these are not law per se, these are frameworks that, if followed and if maintained, give a presumption of compliance. SR 11.7 is a Federal Reserve Board, believe it or not, 2011, provided information on how to maintain and control models. Models are still relevant in the use of AI, very much relevant. And so this SR 11.7 from 2011 is extremely valid today. And obviously the NIST AI risk management framework. It's a framework driven by NIST, who's a non-governmental entity that provides technical guidance to an industry on how to establish the appropriate controls, requirements, and how to actually deploy and maintain technology when it's used in heavily regulated verticals. And at the end of the day, tracking to the ever-changing policy environment. Policy is changing monthly, quarterly, yearly. CCPA, that's the first and actually only consumer privacy protection agency from the state of California, who's chartered with consumer privacy protection at the end of the day. We're going to see AI rules coming out of this agency. They are the specialists that are going to drive California law. They've made an attempt already. It's been pulled back. The governor has empowered the CCPA to do the right thing, but also, there's a lot of awareness now on the negative implications on tech because the big tech lobby is very powerful. Federal Trade Commission, CFPB, and obviously the various state rulemaking trajectories. We're going to be managing to a patchwork of state requirements in the absence of an overarching federal law. It's highly unlikely a federal law regarding AI use in financial services is going to happen anytime in the near future. It's highly probable the states are going to give us various interpretations and various obligations for which you will need to be responsible, whether you're a financial institution or a vendor. The model inventory, model tracking protocol, obviously your policies and procedures. What policies and procedures need to exist, what they need to contain, and how these policies and procedures not only reflect your usage, but how they map and marry to best practices. Business justification and fair lending reviews, and AI-specific model risk controls. Everything we've talked about has to be clearly defined, clearly delineated, and these policies and procedures are what I refer to as dynamic. They cannot be static. As models change, as deployments change, documentation reflecting the models, the enhancements that the vendors make, the policies and procedures are living, breathing documents, and they need to change just as quickly. Obviously the implications of adverse action. The CFPB in the prior administration was very clear. They came out with guidance, which has been shelved. But the guidance basically said, if you use AI, make sure the outcome maps to a rational determination, because that's a major consumer protection. Technical interpretations and the interpretability of a framework. Just someone in the organization needs to understand the tools and the tools use. And obviously, what needs to be organized prior to examinations and prior to the responses. This is documentation that a state regulator or a federal regulator might ask for in advance of an examination. You need to have the documentation available at your fingertips and ready to go. There cannot be a lag in your providing a response. And the more comprehensive your documentation, the less invasive the examination is going to be. At the end of the day, these are the key elements to remember. AI is not plug and play. You just cannot use a vendor and let the vendor operate in a vacuum. It's an extremely high-risk technology that brings immense value, but along with immense value brings considerable risk. Again, you cannot rely on your vendor for your regulatory obligations. Compliance obligations are that of the regulated entity, and the regulated entity is responsible for downstream enforcement. And obviously, the compliance legal governance frameworks must be dynamic, and they must reflect the current methodology and models and practices of your tools. And we find ourselves 2 minutes over. Thank you very much for your time. 30 minutes plus 2. In the event you have any questions, please feel free to directly follow up. I'm always available to answer questions, to provide as much information as I can based on my inherent knowledge restrictions. But at the end of the day, what we do at Garris Horn is we are here to support our clients for being responsible. We motivate our clients to use AI responsibly. We want them to use AI responsibly, and we want to help them understand what they need to do to use AI responsibly. Thank you so much. I wish you a great afternoon.
Thanks for joining us for today's HIT webinar. That was a lot of great information packed into 30 minutes. If today's session sparked any questions or concerns about how your institution is handling AI, cybersecurity, or vendor oversight, we encourage you to reach out. You can contact John directly at jlevonick@garrishorn.com or visit us at garrishorn.com to learn more about how our team can support your legal and compliance needs. And if you have any feedback on this session or ideas for future HIT topics, I'd love to hear from you. You can reach me anytime at afowler, that's AFOWLER, at garrishorn.com. Thanks again, and I hope to see you at the next HIT webinar.